Okay, we're going to go ahead and get started. We know we're lacking a few people because we're competing with the solo practitioner panel, which is a good panel to attend. I attended last year, but we are missing some more students. The way it's going to run today is I'm going to do a very brief overview of how a round goes, and then Professor Pratt and the Marshall team are going to give you guys a demonstration of their arguments. They just returned from their competition and did very, very well. And we'll talk about that a little bit more in just a minute. The way a round runs, just to give you the logistics very quickly, is you'll be assigned to a room. You'll come upstairs or downstairs, wherever it is. You'll come into the room and sit down. Petitioner 1, petitioner 2, respondent 1, respondent 2. Nobody else will be in the room. The bailiff will come in, announce that court is in session. The judges will come in and sit down. They'll get their little papers together, at which point it'll be up to petitioner 1 to go in and start. Petitioner 1 will argue for 10 minutes, then 2 for arguing for 10 minutes, respondent 1 for 10 minutes, respondent 2 for 10 minutes. At the conclusion of the arguments, the contestants, competitors, will go outside for a few minutes. The judges will talk, bring you guys back in, give you a little bit of critique, and that's how the round goes. So with respect to what we're about to hear in this round, Professor Pratt's going to give us a little bit of an overview of what this case involves, so we can all follow that a little bit. Professor Pratt.
Don't ever call me professor again. What we're going to do today is an abbreviated version of this argument. In practice, this would actually be 1 hour. It would be basically 15 minutes per person per side for a full hour. But we're going to do a condensed version where Colby will speak for 10 minutes and Katie will then speak for 10 minutes. And as a quick factual background of this case, we're dealing with a gentleman called Mr. Nevelson, Philip Nevelson. He was a professional diver, an amateur diver who was trying out for the Olympics. Fairly popular gentleman, lived in a high-class part of town where double-decker buses drove people around to view their favorite celebrities. At one point, Mr. Nevelson was sitting in the upstairs portion of his home smoking tobacco from a hookah, and he was also drinking wine. And while he was smoking this hookah, a camera captured an image of him so doing. This camera was actually one of about 9 cameras attached to basically a ball that was on a pole, that was on a car that was driving down the neighborhood. And the respondent in this case is Marshall, and Marshall, as you might assume, is a spinoff of Google. And they were driving down the street to tape the roads, record portions of the roads for this mapping application, sort of like you would get on Google Maps. So the question before the court is whether Marshall invaded Mr. Nevelson's privacy by driving this contraption down the street and taking a photograph of him smoking a hookah. And then subsequently, a reporter, a little unclear as to whether it's a Marshall reporter, posted a link to this image and said, if you want to see what the $3 million man in Marshall does in his spare time, follow this link. There was a business deal on the table for $3 million, wherein Mr. Nevelson would receive $3 million from an organization called Sunshine Athletic Wear if he made the Olympic cut and was qualified for the Olympic trials. He also had some other endorsement deals. The only other specific one that we know of is with the Marshall Community Against Drugs, or pardon me, the Marshall Campaign Against Drugs. So there's this issue of, did they invade his privacy by taking the photograph? Did they invade his privacy by posting the photograph? And did they interfere with these business expectancies with Sunshine Athletic Wear, the Marshall Council Against Drugs, and the other speculative endorsement deals? Mr. Nevelson would certainly argue that they did in fact invade his privacy, that they did in fact compete with his business expectancy and interfere with that expectancy. So what you are going to hear now is the respondent, Marshall, in response to the arguments that would have previously been raised by Mr. Nevelson in those regards. So I will sit down and we'll get started.
Justice. May it please the court. My name is Colby Gunnels, and I, along with co-counsel Katie Woods, represent Marshall Incorporated. During my time before the court, I will address both of Mr. Nevelson's claims for invasion of privacy. Ms. Woods will then address the claims for tortious interference with business expectancy. With regard to the claims for invasion of privacy, the question before the court is this: does a star athlete forfeit his actionable right to privacy when he knowingly presents himself in front of an uncovered window? The answer is yes for 3 reasons. First, there can be no expectation of privacy in what is knowingly left open to view of the general public. Second, a reasonable person would not be offended at a photograph depicting only what is visible from outside the home. And third, with regard to the claim for public disclosure specifically, Mr. Nevelson chose a course of endorsements that made his drinking and smoking a matter of public concern. And therefore, Your Honor, the circuit court was correct in granting summary judgment, and the Court of Appeals should be affirmed.
Counsel, let me ask you this. It sounds like in your recitation of your arguments there that your entire argument revolves around this idea that it was an open window. Is that essentially your argument today? The window
Yes,
was
Your Honor.
open, so we could do what we want.
Yes, Your Honor.
So are you saying then that if I'm walking out the front door of my home and I just so happen to walk out just at the exact moment that this contraption drives down the street, and as I open my door, my children are playing behind me and they're running around in diapers, are you saying that that doesn't invade my privacy and my children behind me just because I happen to open the door at that very moment?
Your Honor, the answer to that question is twofold. With regard to you, if you're opening your window, if you're opening your front door and leaving your home, your expectation of privacy is going to be diminished as you exit your home. But with regard to your children, they are then further inside the home, and they would present a greater expectation than Mr. Nevelson has here. Mr. Nevelson was standing in front of a window, essentially making himself the same view as the rest of the exterior of the home. And the Illinois Court of Appeals in Schiller versus Mitchell has held that there is no expectation of privacy in what is already visible from outside the home. In that situation, the defendant neighbors installed surveillance cameras specifically for the purpose of recording the outside of the plaintiff's home, constantly recording the home. But the court there held that there could be no expectation of privacy because the view was only from outside the home.
But as I understand Schiller, that case dealt with a camera that was videoing the outside of the home, the external part, the bricks and the wood and everything that's around the house. But what your client did was use a contraption that managed to capture an image of Mr. Nevelson inside of his home. His home, the very vessel of all privacy, the element that has more privacy in the law in this country than anything else. And I think one case is referred to it as something along the lines of what is it? I think you know the case I'm talking about.
Yes, Your Honor, it has been referred to as the expectation of privacy at its zenith. But that's inside the home. Mr. Nevelson made himself a view of the outside the home by
But he's
presenting.
still inside, man.
Yes, Your Honor, but this was the same situation confronted by the Federal District Court of Maryland in an unpublished opinion, Sullivan versus National Enquirer, following the precedent set by courts like Schiller versus Mitchell that said the exterior of the home has no expectation of privacy. In Sullivan, the plaintiff had made herself a part of that exterior view when the defendants caught a photograph of her standing in front of an uncovered window in the upstairs of her home. The court there held that the defendant did not invade private facts because the plaintiff had exposed herself to that view of the general public.
But isn't that case a little bit different? I mean, wasn't she directly in front of the window? Hadn't she placed herself directly in front of that window while talking on the phone? I mean, Mr. Nevelson wasn't standing in front of the window. He was sitting down, somewhat back away, I mean, a little deeper into the room, sort of like the children that I was discussing earlier that were a little farther back. So it seems that what we're looking at here is the expectation, not whether there actually was or was not, but the expectation, and whether that expectation is something that reasonable jurors are willing to give. And under the procedural posture of this case, I just don't see how this is not an invasion as a matter of law.
Your Honor, it is not an invasion as a matter of law because, as the record at page 6 reflects, Mr. Nevelson was situated in front of his window such that anyone from the street could have seen this same photograph. And it's also important to note that a photograph taken in this manner is also not highly offensive. That was what was discussed by the Pennsylvania District Court, Boring versus Google. In fact, very similar to this one. In that situation, Google was taking photographs to upload to its internet mapping application as well. But importantly, these photographs in Boring versus Google could not have been taken from a public road. And there, Google had to drive back onto private roads, back onto private property, past signs declaring no trespassing. But the court held that because those photographs only essentially took pictures of what was visible from the exterior of the home, only the most sensitive person could take offense at a photograph taken in that manner. Your Honor, that's the same situation we have here, except even less offensive. This
So
photograph.
are you saying that Mr. Nevelson wholly failed to have an expectation of privacy as a matter of law? You're telling me that reasonable jurors could not disagree as to whether his expectation of privacy existed and was reasonable?
Yes, Your Honor, and that's exactly what both the Circuit Court and the Court of Appeals have already decided, that because Mr. Nevelson made himself the same view as anyone else could see from the exterior of the home, he therefore had no expectation of privacy. It's also important to note that the record at page 7 reflects that Mr. Nevelson overcame his own expectation of privacy when he moved into the Emerald Hills area, an area known for its celebrities and known for tourists taking pictures of these celebrities. And then Mr. Nevelson not only did that, but he overcame his own privacy fence when he went up to the second floor above the protection of the fence so that anyone from the street could have seen the same view that was captured here. Your Honor, it's also important to note that Mr. Nevelson has failed to establish the intent required for intrusion upon seclusion. The Third Circuit in O'Donnell has held that intrusion upon seclusion is an intentional tort, and as such, Mr. Marshubel need not just have intended the act, but need to have intended the intrusion itself.
Well, but can't we infer that that intrusion was in fact intentional? I mean, given the procedural posture of this case, we have to make inferences in favor of Mr. Nevelson, and it seems that that's a reasonable inference that we can draw, especially when you look at the events surrounding the actual capturing of the photograph. I mean, you've got your client previously disparaging Mr. Nevelson, you've got your client posting a link to it with a questionable phrase that seems to, at a minimum, insinuate drug use. So all of those things taken into account at the same time seem to at least give facts that would lead a reasonable juror to possibly, at least, conclude that this was intentional.
Not in this situation, Your Honor, because as the Third Circuit noted in O'Donnell, and as the Maryland Court of Appeals in Baylor versus Erie Insurance Exchange have noted, the intent element of this tort is much higher than normal. And the Maryland Court of Appeals even noted that not even a negligent intrusion in this situation will suffice. And the record is clear that Marshubel was in this situation taking pictures for its internet mapping application. And even though it uploaded that picture going to Mr. Nevelson's claim for public disclosure of private facts, they were privileged to do so because Mr. Nevelson had made himself newsworthy. The requirement for this is that the matters published have been related to those things which made Mr. Nevelson famous in the first place. And in this situation, that is met, as the record reflects. Mr. Nevelson was a professional diver. He had numerous endorsement deals, including that which is highly publicized with Sunshine Athletic Wear, but he also presented himself as a role model. And when Mr. Nevelson is in the one hand presenting himself as a role model, and on the other hand smoking and drinking in front of him.
But come on now, let's be fair. I mean, this role model status you're referring to arises out of his obvious celebrity status, and I think you're probably going to this deal with MCAD. But the MCAD deal was against illegal drugs. I mean, he was only smoking tobacco. And we're now left at a position where if you win, that insinuation that he was doing drugs sticks. He never gets to have his day where the realities come out. You're asking us to give you a win based on assumptions captured in a photograph that your client took.
Your Honor, I see my time is running out. May I
Please
answer your question? Thank you, Your Honor. Your Honor, what's important to note is with the picture Mr. Nevelson has painted of himself by his own acts and his own declaration, he has declared himself a role model. The only legal issue is whether his declaration that he's a role model is related to the fact that he smokes and drinks in front of his own window, and especially to MCAD and to those parents to whom Nevelson's talking to their children as presenting himself as a role model. there is a connection there for that purpose. Thank you, Your Honor.
Good job.
Chief Justice, may it please the court, I'm Katie Woods, and on behalf of Marshugel, the respondent, I will be addressing the third claim of tortious interference. Specifically, the question before the court is whether Mr. Nelson established the elements of tortious interference with a business expectancy. The answer to that question is no, for two reasons. First, Mr. Nelson was unable to show purposeful interference. And second, Mr. Nelson was unable to show a causal link between Marshugel's conduct and the damages claimed in this action. As an ancillary point, Your Honors, this action involves a protected communication. Therefore, this court should affirm the lower court's holding in granting of summary judgment.
Well, you just said protected communication. Does that mean you're trying to raise the First Amendment type freedom of the press claim here?
Your Honor, specifically the communication in question is the communication posted supposedly by a reporter on the Marshugel map feature on the sports blog news. And yes, a First Amendment claim can be brought in addition to a claim on competitive business actions, and that is also seen as a privilege in this instance.
Was that raised below?
No, the First Amendment claim was not raised below. However, in Mannion v. Stone Springs, an Illinois appellate court case, it specifically stated that in actions of tortious interference with the business expectancy, privileges can be brought up on appeal if it's apparent on the face of the claim that a privilege may apply. In this instance, since the claim is a protected communication, a communication specifically posted on a blog meant to be a newsworthy source of information, that would make it absolutely apparent. However, if this court determines that it is not apparent enough to raise the First Amendment issue here, the privilege can still be considered under an analysis in the Downers Grove factors, which falls under improper conduct, specifically required by the tort in the purposeful interference point, which brings me to my first point. Mr. Nelson was unable to show purposeful interference. The Marshall State statute specifically requires purposeful and has left out what the restatement's second tort had included in the past, intentional, allowing for a mere showing of substantial certainty. Here, that is not the case. The Marshall State statute has thrown out the substantial certainty requirement and stuck with an intentional and deliberate act to fall under a purposeful, tortious interference with the business expectancy. Here, Your Honors, Mr. Nelson has failed to show the purposeful intent to interfere with the business expectancy.
Well, but whether we're looking at this as a purposeful or an intentional or whether substantial certainty works, it's kind of the same issue that I was having with your co-counsel, which is the procedural posture of this case puts us in a position to where if there are facts in the record upon which reasonable jurors could disagree, then your client doesn't win in summary disposition. This is a case that should go to the jury. And it seems to me that the facts in this case suggest that there was some purpose to interfere with Mr. Nelson's expectancies.
Your Honor, as to your first part of your question, yes, in a case where there are facts in the record make a reasonable difference, that is the case, then our client would lose. However, in this instance, it was the plaintiff's burden to place facts in the record to show purposeful interference. It was also, under that category, the plaintiff's burden to show improper conduct, which would go to the purposeful requirement. However, Mr. Nelson has failed to meet his burden in placing those facts that state purposeful interference or show improper conduct. Specifically, Your Honor, under improper conduct, Restatement Second of Torts, Section 762B, a similar statute to that of Marshall State statute specifically requires improper conduct if it is independently wrongful, then the interference is essentially improper. But here, where there's a mean that's used that are innocent or less blameworthy, then the conduct cannot be shown to be improper on these instances. In addition,
the improperness comes into play from the point that people to enhance, copy, comment, etc. He requested that it be taken down. It took him 7 days to take it down. They directly referenced his $3 million deal. How do those facts not create an issue or a question of fact with regard to whether they purposefully interfered?
Your Honor, if I may, it's going to take me four
Certainly.
points to answer your question. First, the posting of the photograph is an intentional posting of the photograph to update a map feature, which is specifically designed to market towards Marshugal's clients in both searching for possible locations and getting directions, or future residents of a neighborhood, so that they can survey a house and see if they like its locale, if they see if they like their surrounding neighborhood.
Okay, if I buy that, what about the link?
Your Honor,
What's the purpose for that?
that brings me to my second point. The link specifically makes a comment about Mr. Nelson's $3 million deal. However, there's no indication in the record that it was Marshugal's reporter that posted the link. And in addition to that, the specific comment cannot be based to interfere with a business expectancy, which brings me to my second point of my argument, because Mr. Nelson cannot base a tortious interference claim on claims that are contingent upon something else. That $3 million endorsement was purely contingent upon his qualification for the Olympic team. Mr. Nelson himself failed to qualify for the Olympic team. In fact, as the record indicates, it wasn't a poor qualification as the petitioner would have you believe. It was merely a third-place finish. He would have had to place either first or second, and Mr. Nelson still made a good showing, however, stepping up into a higher competition level that far exceeds that of the junior world qualifiers, as the record would indicate, where he had done really well previously.
Well, but isn't it a reasonable inference to draw that, I mean, your argument almost works against you. I mean, you're saying he placed third, he almost made it. So if he's that close, then it seems to me that that supports Mr. Nelson's argument that had he not been out in the media attempting to regain his good name, that was damaged as at least a starting point of your client's actions. You know, if he wasn't out there, if he wasn't losing sleep dealing with it, if he wasn't having to deal with the media and say, hey, I was smoking tobacco, it wasn't anything illegal. If he hadn't had to do all that, maybe he could have practiced and got that one extra spot up that he was already so close to.
No, Your Honor. In fact, it doesn't go against my argument. It specifically proves the argument here at stake. Number one, the contingency deal. And in cases such as Yost versus Lengo, a California Supreme Court case that specifically analyzes tortious interference with the business expectancy and athletic competition, says that those athletic competitions are too speculative to be based on a tortious interference claim. In addition to that, Your Honor, Mr. Nelson himself, as the record indicates, decided on page 12 of the record to go out and try and mitigate his reputation within the community. It was Mr. Nelson's decision, number one, to participate in the activities that he did. It was also Mr. Nelson's decision to become a role model in the community and coming and speaking out against drugs and alcohol activities to the youth in the community. It was not Marshugal, but it was Mr. Nelson that placed himself in the media for numerous hours on numerous various occasions.
But it was also the actions of your client that started this ball rolling that eventually forced him to go out and seek to claim his good name.
Your Honor, it could be said that the photograph is the instance that you're saying, the ball rolling. However, the circumstances in this case say that the posting of that photograph is too attenuated to prove the causal link, which falls again under my second point. Mr. Nelson was unable to show that the damages caused to his reputation, to his failure to qualify for the Olympics, were the cause of Marshugal's actions. Specifically, Your Honor, as you had mentioned to my co-counsel, he has no other claims that he could have. That is not the case in this instance. Mr. Nelson could attack the individuals and the news media outlets that specifically published improper facts or incorrect data about his drug use and extracurricular activities. In this case, Mr. Nelson failed to add in those parties that he could have had a valid and substantial causal link to the damage of his reputation and to the damage and his failure, may I briefly conclude? To make the Olympic team. For these reasons, Your Honor, we ask you to affirm the lower court's holding.
How dare you?